Okay, Attorney Stevens.
Good morning. My name is Bethany Stevens, and I'm an Assistant District Attorney in Middlesex. Your Honors, the order requiring the Commonwealth to transport all the evidence in the case, which included a 40 caliber firearm with a large capacity feeding device loaded with 11 rounds of ammunition, to court 5 days after the defendant's arrest, to be opened by defense counsel, caused the crime lab to expedite the processing of the firearm that
Stevens,
day.
I think I asked you the last time. Put it on slow, please.
That was slower, but I'll try more. Thank you.
Thank you.
But it's that order that caused the crime lab to expedite the processing of the firearm that morning that resulted in the DNA swabbing of the firearm and the test firing of the firearm. The crime lab was not on notice that there was any order prohibiting that expedited processing, and nor should there be, as the ex parte filing that the Commonwealth subsequently learned after the 11-day sanction hearing, when those ex parte filings were finally revealed to the Commonwealth. The only basis was for the defense to conduct a smelling test on the marijuana evidence. The crime lab did not have any order that they were not to test the firearm, and to punish the Commonwealth for the events that took place that morning on September 10th would be unjust, where the firearm was only included in the order as a ruse to keep... Yes, Your Honor.
Finish your sentence.
Well, it was only included as a ruse to keep the Commonwealth from knowing that the defendants wanted to smell the marijuana evidence.
Two questions. One is, with respect to the marijuana, I mean, it seems to me not an unreasonable interest on the defendant's part that they, since that was the basis of the started this whole ball rolling, to smell the marijuana. How would you suggest they? And I'm not saying this is the. I'm just asking the question. How would you suggest that if you're a defendant interested in smelling the marijuana that was used, they should have gone about it?
I would suggest that there's no basis to do that ex parte. There's no reason to not tell the Commonwealth and let us argue in court that issue and discuss the parameters of how that smelling test would be conducted.
What about if the defense came forward and said, we want an order, and this, not ex parte, we want an order that nothing be done with the marijuana, and the reason is, and the judge could issue the order then, that day, if he wanted to take it under advisement, or he could decide from the bench right then and there. I mean, to me, this case is just a mountain made out of a molehill, and that everybody should have handled it at the district court, and it should have been disposed of.
I absolutely agree that in hindsight, looking at the events, but you have to realize how the events played out. It was on September 9th that an ADA who was in court on an unrelated matter received this order. It's at Addendum B, and reading that order, that signed order, he then distributed it to the crime lab. And if I could just go through the events of the morning of September 10th.
Okay.
At 8:30 a.m., the Commonwealth filed a petition for relief from the order requiring transport of all of the evidence to be transported to court to be opened by defense counsel before it had even been processed. It was 5 days after the defendant's arrest.
I take it at that point, the gun was already at where? The
It was
lab?
at the crime lab. It
The
was.
crime lab.
That's correct.
The marijuana was still in the police locker.
Correct. And Justice Singleton ordered the Commonwealth to maintain the marijuana at the police locker, despite the fact it was due to be transported to Foxborough the next day. The Commonwealth conveyed that order, and the marijuana did stay at the barracks throughout the entire time.
At Leverett Circle.
At Leverett Circle, exactly.
And wrapped in plastic? Was it still wrapped the same way it had been when
It
taken
had,
from
and then
the
it was
scene?
inside a clear evidence package. And
I have one question for you. When the trooper came to court, as you say, in full uniform, blah, 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 with the packaged marijuana, it appears that the Commonwealth did not notify either the judge or the defense counsel that the trooper was there with the marijuana. Is that correct?
that's correct, because
Now,
there
why
had...
did you not do so? Why did the Commonwealth not do so?
The Commonwealth was seeking a stay of the order, and a stay was granted at 9:50 a.m. When the case was called, we had till 10 o'clock to comply with the order. When the case was called, the prosecutor relayed to the court that the single justice had stayed the order. To suggest that we had a duty to tell the defense counsel the marijuana is here suggests that the defendants could then just ignore the single justice's stay and go on with their inspection. I mean, that was what we were trying to do, was to clarify this
answered my
order.
question. The order was stayed at 9:58, so that
At 9:50.
Yeah.
9:58.
9:50.
Correct.
I didn't see any such order in the materials.
There was an oral stay issued by the single justice that was conveyed to all of the parties. I mean, the Commonwealth's goal was to seek a stay of the 10 o'clock order. I think it's undisputed that a stay did issue at 9:50, and it would be illogical for the single justice to issue a stay after the required event.
Okay, so a stay issued at 9:50, you say,
Correct.
and then did a written order issue from the single justice later that
At
day?
1:50 p.m.
Is that in the materials?
That is in the materials, and that would be at Record Appendix 72, page 72. There was initial written order by the single justice issued at 1:50 p.m., and then there was a subsequent order after that, a number 2 order. That's at pages 74 of the Record Appendix.
If I could take you back, let us assume for the moment that the judge erred in permitting an ex parte hearing. All right? Let's assume that that was error, but nonetheless an order was issued.
Correct.
Is it your position that the Commonwealth was not obligated to comply with that order until it was vacated?
Absolutely not, Your Honor, and we took steps to comply with that order while also seeking relief from the order, which Justice Singleton also recognized we do have the right to do, and that's at volume.
Okay, so the fact that it's ex parte is not critical to this issue.
Yes and no. I mean, what ended up happening, the result of it being ex parte, was that the Commonwealth was forced to pretty much advocate for its rights in the dark and not knowing what the real issue was and spending...
So you're saying that the confusion was caused by it being ex parte, but in terms of the lawfulness of the order, you're not contending that it affects the lawfulness of the order?
Well, the Commonwealth does not believe that the order was lawful, that this is not a lawful ex parte basis to issue the order.
Right, but you're not contending that the Commonwealth could validly ignore it if it were not vacated?
Absolutely.
Okay.
Absolutely. The Commonwealth is not seeking to disobey court orders. We're seeking to seek relief from them through the proper channels.
Okay, now, if I could take one more step. Now, let's assume you have an order, and I know your contention here is that there was no violation of that order. But let's assume, for the sake of this argument, that there was. Let's assume we had a different situation in which there was an order issued. The Commonwealth chose to ignore it, didn't choose to appeal it. And let's assume that as a result of that, the defense had to do a motion to compel and had to incur additional attorney expenses. Is it your view that a court could not sanction the Commonwealth for its failure to comply and assess attorney's fees for that violation?
Well, I think that while at some point the principles of sovereign immunity might prevent the assessment of costs against the Commonwealth, whether the judge has the authority to reappropriate or redistribute taxpayer money is not necessarily a question that needs to be answered in this case.
Costs or fine? Costs? You said the court doesn't have the power to assess costs against the Commonwealth for costs?
I'm not suggesting that in some circumstances there may be. I mean, under Rule 48, it does...
We have a case, Commonwealth versus Gonzalez, and didn't we do that in that case?
Well, I suggest in that case that was actually authorized by the legislature. Section 28 that allowed the Commonwealth's appeal originally provided language that the Commonwealth would pay for those appeals.
Doesn't Rule 14 itself for discovery... Again, just as a general matter, I'm not saying in this case, but doesn't, as a general matter, Rule 14 allow for a sanction cost that it may include paying attorney's fees in an example such as Justice Gantz just gave?
Right. The language of Rule 14 provides that sanctions can be imposed whatever is just under the circumstances, and I would suggest that language requires just must be in accordance with law. And Rule 48 does provide for sanctions in the form of costs or a fine, but it's only for a willful violation of court orders.
So I understand that, but I think
that was the example posed, really.
Right. I mean, I would suggest that Rule 48 is directed at counsel as opposed to the Commonwealth. But again, I think the issue is more whether a criminal defendant has the standing to be able to pursue an action for sanctions to solely punish the Commonwealth.
Well, what do you say about Commonwealth versus the 1987 Ford Econoline van case, where this court approved or required the Commonwealth to pay attorney's fees or to pay the fair market value of the van if it did not return it, along with an additional fee?
I mean, I do think that when there are remedies, when this is an exercise of equitable remedies and to reimburse for unnecessary wasted resources, that there would be an appropriate authority to do that. I would just suggest that it's not in this case. And here, the $25,000 sanction is not tied in terms of any sort of any unnecessary resources. It's not clear where Justice Singleton got this $25,000 fine from. So it's clearly not aimed at any unnecessary resources wasted.
So you would suggest that was essentially a penalty versus costs?
Absolutely, Your Honor, especially where in addition to the $25,000, he also assessed attorney's fees, depending on the affidavits to be filed with the court. But here, he was finding an intentional and deliberate violation of a court order, and there's absolutely no basis to find that.
I'm not saying there was any intentional or deliberate violation of a court order, but what about the fact that the defendant, I don't see why there wasn't some prejudice to the defendant, but it's probably of his own doing because of all this going behind everybody's back, but what the defendant wanted was a quick smell, not a smell a week or two later. And so wasn't the defendant prejudiced because they didn't get a smell right away?
I would suggest there's no record to believe that. I mean, first of all, the order came 4 days after the arrest. So, I mean, I don't know how much difference the prejudice would be from 4 days versus a week later. Secondly, the interest was to...
Wait, when did they get an order that they...
4 days after the defendant's arrest, which was due to be effective 5 days after the defendant's arrest.
But then the order was stayed by the single justice.
Correct. So that put it off another week. But I'm just saying...
I'm saying, so they didn't get an actual smell in this case for quite a while. A lot of it due to their own fault.
But the other point I'd like to make, though, is that it's not that they didn't have witnesses for the smell. The 3 defendants were in the car at the time and could testify to that as well.
It would be much better if they could have had, say,
and the other point that I'd like to...
Well, is there any reason to believe that they couldn't have gotten an opportunity to sniff the contents of the bag by filing a motion with notice to the Commonwealth?
Absolutely, and then we could have actually litigated. The Commonwealth could advocate our rights, and if the court acting as referee doesn't want to side with the Commonwealth's advocation, then they'll call the shots. But here, and I think the other point that the Commonwealth didn't have an opportunity to make is, are we really conducting the smell test on the marijuana evidence? I mean, the vehicle stopped, the car smelled of marijuana. Does that really mean that it emanated from these particular bags of marijuana? But these were arguments that the Commonwealth was not able to make because we were never able to address the real issue.
All right, let's go back. We have the 950 oral motion to stay what the district court judge had ordered, which was the 10 o'clock production of this evidence in court.
Correct, Your Honor.
And then we have the written stay order later on in the day.
Correct.
And I take it one of the issues here is whether or not the Commonwealth was permitted between 950 and whenever the order came in at the end of the day to actually do some testing on the gun, for example.
Correct.
Because the judge's order that came in at the end of the day, it seemed to me, suggested that there should be no further testing.
Maintain the status quo of the evidence, correct.
And your position is that the 950 stay didn't include that proviso?
It did not. Now, the prosecutors...
Now, what proof do we have of that? There's no written order. What is it? There's an affidavit? What? Because it's clearly the written order did. The written order included that limitation.
It did, but there was, I mean, this was the defendant's motion for sanctions. There was no evidence offered that there was any kind of status quo ordered at the 9:50 a.m. Now, I will tell Your Honors that the prosecutors did understand that the best practice was to maintain the status quo of the evidence, but that wasn't communicated to the crime lab until after the single justice issued the stay. ADA Mulcahy left a message for Trooper Wall. She was at a section meeting and then went out to lunch, and he didn't get a message to return the call to ADA Mulcahy, who was going to tell him the best practice would be to maintain the status quo. Trooper Walsh expected that the gun, knowing that the order had been stayed, very likely could be required in court fairly imminently, and so wanted to finish the processing. When you look at Addendum B of what the crime lab had before them, there's nothing...
So your view, he was supposed to have the gun in court at 10 o'clock, so at 10 of 10, obviously the gun is still out at the lab. It's not in court.
That's correct.
It's not coming to court.
The prosecutors didn't know that, but that's correct.
All right, it's not coming to court. The order that the district court judge, 2 orders issued the day before, your position is those orders permitted the testing?
It's our position that, okay, the first order, the Commonwealth received an unsigned copy of that order, and that's the only order that says anything about testing. They want to have an immediate inspection prior to the transport to any lab for testing. The Commonwealth.
Don't you have to read that as saying no testing?
But if you could just bear with me 1 minute. ADA Mulcahy received that unsigned copy of the order when he was in court on an unrelated matter. He went back to his office after he was finished in his court duties, and he sought guidance as to what his obligations were with respect to this order. What should he do with this order? He returns to court to ask for clarification of the order, and he finds Attorney McGowan there recalling the case. He just happened to show up. She reported that the state police refused to comply with the order. Justice Singleton, it didn't sit very well with him. He ordered that the marijuana evidence be held at the barracks.
According to your brief, that was somewhat a misinterpretation of what the state police told her, as I read your
That's
brief.
correct, Your Honor, because they were never...
She said he had to give it to legal. He'd never seen this before.
They never presented her with the order, and if you read Addendum A, that does not indicate to anybody that you're allowed to open the evidence packaging. So what they did was they sought at 2 o'clock a new order, a revised order, that clarified that the opportunity to inspect meant opening the evidencing package, and because they now had information, Attorney McGowan reported to the court that the marijuana is still at the barracks, but the firearm had already been transported to the Maynard Crime Lab. They then also said, regardless of where the evidence is, you need to transport it. Now, if there was any intention of precluding us from testing the evidence, knowing that the firearm was at a crime lab, a place where testing is conducted, you would expect that information to be put into the order.
You mean in the second September 9th order?
Correct, Your Honor, correct. And so the Commonwealth only had this signed Addendum B here, this second order that we're dealing with, and it seems that we're trying to interpret this order in a vacuum. We don't know the basis of the order, and we're trying to do the best that we can to comply with it. We fax that to everybody, and we get the marijuana in court, the firearm, the crime lab interpreted the order that this requires expedited processing so that they can get it to the court without contamination.
What time was the DNA swabbing, and what time was the first test firing of the gun with the inventory shells?
With the inventory shells, that occurred on September 5th. Because this was a Boston Police Department and was involved, the gang unit, their practice is to automatically upload any firearms they recover into NIBIN.
What time of day?
September 5th. I think the defendants were arrested in the early morning hours of September 5th. Sometime, I'm not sure if I think it was the afternoon of September 5th. But these orders didn't issue until September 9th. None of this came to the prosecutor's attention until, the orders that the defendants were seeking.
And what time was the DNA swabbing done?
That was on September 10th at 9:43 a.m. So if I could just quickly, I could go through.
Well, unless there are other questions, you're out of time.
I have one question.
I have 2 more minutes. Okay.
One question, and that is, there's a lot of criticism of Assistant District Attorney O'Neill's, I think, affidavit as being not truthful, that one filed with a single justice, I think.
I think it's the affidavit of the DNA specialist, Kristen Sullivan. So what had happened there was, and I just want to point out, first of all, that in Judge Singleton's sanction order, in footnote 1 there, he finds that there was no court action taken. There was no action taken in reliance of this affidavit. The Commonwealth filed its 211-3 petition at 8:30 a.m. and did not submit that affidavit until after the stay issued at 10:09 a.m. The stay issued at 9:50 a.m. The Commonwealth submitted a supplemental petition at 10:09 a.m. All that happened as a result of that affidavit was that the court, the single justice, allowed remanded the case back to Justice Singleton to make findings and to consider the affidavit. That was on September 10th. On September 11th, the hearing was held where the Commonwealth again advanced our contamination concerns.
But the question is whether, when it was filed, was it accurate?
When it was filed, it was actually. The gun had been processed for DNA at the time it was filed. That is correct. But that was just a miscommunication, and as soon as the Commonwealth found out on Friday, September 12th, we withdrew our objection to the firearm. And that just demonstrates that we were really just concerned with the contamination of the evidence. Because being this most serious piece of evidence in the case, as soon as we found out there were no more contamination concerns, we did withdraw our objection. And we would just ask this court to vacate the sanction order, to find no sanctions are warranted so that we could lift this 2-year stay and allow us to prosecute the defendant.
Thank you.
Thank you, Your Honors.
Mr. Beck?
Thank you. Daniel Beck for Keyson Carney. The Commonwealth's argument about the contamination is simply a pretext. It's their best
Mr.
argument.
Beck, but let's get to why you thought it necessary, or Ms. McGowan thought it necessary to, or appropriate, to seek an ex parte order for a discovery here.
As in Confi Mitchell, which dealt with Rule 17, one of the questions is whether there will be some sort of tampering with the evidence. The police, reading the police report in this case, every so often as a defense lawyer, you get a police report and you look at it and you kind of roll your eyes and say, come on, you don't really expect us to believe that. That was one of these reports. I mean, we're not talking about a routine traffic stop.
But was the which police agency made the stop?
The state police, along with the Boston Youth Violence Strike Force.
So why does that, even if it's a roll your eyes type of police report, that says, okay, we can go in ex parte?
It says that there's a danger that the police, who are clearly, in my view, were not being particularly honest in their police report, might not have qualms about tampering with evidence.
Well, that's quite an accusation to make.
Certainly
in a broad
is.
sense. And that accusation doesn't even go against the Boston police. It goes against the state police crime lab, which wasn't involved in the arrest. So you're suggesting that the state police crime lab was going to tamper with the evidence in this run-of-the-mill, to say, drug and firearm case.
First of all, we did not know that when we filed that the evidence was in the possession of the crime lab. We didn't know where the evidence was, frankly. As far as we knew, it was still in the possession of the police, which is why Judge Singleton issued the no transport order to the crime lab.
But if you had gone forward in court, this case should have been handled, I mean, to me, it's a hex on all your houses, but it should have gone forward in court simply by you coming into court and saying, look, we want an order now not to tamper with the evidence and to bring the evidence right in and let us smell it or have our expert come in and smell it, do it today, tomorrow, and that's it. And this wouldn't be here and shouldn't be here.
I'm not sure that that's correct. I think it would be here anyway. I don't think the fact that it was ex parte was, frankly, the major objection by the Commonwealth.
That caused the whole confusion. The Commonwealth thought you were after the gun, not after the drugs. Yeah.
They would have opposed it. In my view, they would have opposed it anyway.
It's their duty to, if they...
Right, but I think...
But that's right. That's what the adversary system is all about. They would have opposed it. Judge Singleton would have made an order, and that would have... It might have been in your favor.
Oh, I expect it would have been in our favor.
So then and if you said all we want to do is smell the stuff, most likely, I do not think they would have come up here, or that any judge would have allowed them 211(3) relief if they came up here on a discovery order to smell the marijuana.
I can't speak for the single justice, but I firmly believe that the Commonwealth would have sought a 211(3) in any case. They were outraged by the fact that Judge Singleton presumed to tell them what to do with their evidence.
Mr. Beck, was there an affidavit in support of the first ex parte motion?
I don't believe so.
So that the judge didn't have any background as to what the theory was?
There was a hearing, an ex parte hearing.
But not by sworn statement?
Not by affidavit, but by representations of counsel.
What were those
And I gather there's no transcript of that ex parte hearing.
There is not.
So there's no record of what was said to the court.
Correct.
Is it typical for this judge to hold ex parte hearings?
Absolutely not. This was a special case.
Well, I don't see anything so special about this case.
Well, this special was that, as I said, it was a special police report as far as I could see. It was one that was clearly, in my view, and I think Judge Singleton's view as well, not truthful.
How many police reports have you read about cars which stop for traffic violations, and in plain view there is a marijuana cigarette?
Or a smell of marijuana?
A smell of fresh marijuana?
Yes.
Very rare.
Smell of sitting here, we don't hear all that many marijuana cases, and I've seen it in more than 2 or 3. So,
well, I'd say that burnt marijuana is certainly very common. Fresh marijuana, the idea that you can, I mean, obviously if somebody has a truck full of bales of marijuana, that's a whole different story.
My point is just that I don't think this is like unique in the history of the Commonwealth, that this affidavit, that would warrant seeking ex parte relief.
You know, in hindsight, perhaps, you know, we were overly concerned. But at the time, we had just gotten it. We had just been appointed to the case. I believe Mr. Perez actually had just been appointed the day before. In hindsight, perhaps it would have been.
So the police said that, whoever said it, said that he or they smelled fresh marijuana.
Correct.
Do you think maybe they meant freshly burnt marijuana?
No, there was no evidence of that. I think what I think is they were determined to search these people.
No, but why couldn't they have meant freshly burned? I mean, police are not college professors sitting in a room. Maybe that's all the officer meant. And
I mean, I think the court is being very kind to the officer. They know, they may not be college professors, but they write these kind of police reports about marijuana quite often. And they know the difference between fresh, I don't even remember, it may have even said unburnt. It was absolutely, reading the police report, there was no way to interpret that as the smell of burnt marijuana.
So this ex parte proceeding that you brought and that the judge permitted to go forward was all about getting a chance to smell the marijuana.
Correct.
But this 10-day or 11-day hearing after the fact was all about the fact that the gun was at the crime lab and was in the middle of being tested.
It wasn't all about that. It was certainly a good part of it was about that. The marijuana was also referenced. The point is that the Commonwealth disobeyed the court order, and it was more obvious how they disobeyed the court order with the gun.
When you say they disobeyed the court order, the Commonwealth brought the marijuana into court. It was there at 10 a.m. on the morning as ordered by the judge. So what did...
And they never told the judge it was there.
That's because at 9:50 the order was stayed by the
believe
SJC.
As I said, I think that is not the reason. That is true that the order was stayed, but I don't believe the Commonwealth had any intention. As a matter of fact, I don't believe that the...
That's quite an accusation. I mean, you stand up here and make these bald accusations.
Well, I will tell you that there's no evidence that the ADA in the courtroom knew between 9:50 and 10 that the order had been stayed.
Let's assume the Commonwealth intended to violate the order, but the order was stayed. Is there a violation of the order?
Well, given that they swabbed the gun at 9:43, and by the Commonwealth's own admission, the stay didn't issue till 9:50, there was clearly a violation.
And what was
What's the violation?
Yeah.
The order says be here by 10, and so maybe the Commonwealth got lucky with the
No.
stay. But
It also says that the second order, that Commonwealth's argument rests on the fact that they interpret the second order as replacing the first order. Everybody in the courtroom knew that the second order supplemented the
you
first
say everybody
order.
based on what? I mean, as I understand it, the first order says, make all evidence seized in this matter available for inspection to defense counsel and her designees immediately and in any event prior to the transport of
For
such
testing.
evidence for testing. And then it turns out actually it already had been transported. So the next order says, okay, just bring it here at 10 o'clock the next morning.
In the context, the idea that because Ms. McGowan reported that the police said they wouldn't obey the order, that Judge Singleton would therefore rescind the order is just not credible.
No, that's not agreed, but it says bring it in because, as I understand it, you wanted to inspect the evidence, correct?
But it says bring it in prior to transport for testing, which anybody, given that we understood that it hadn't been transported.
But it was already there, wasn't it?
But that has to be read as prior to testing as well.
At the hearing, did the Commonwealth suggest that Judge Singleton himself said, no, it did not include a no testing order? Is that right?
I don't recall that, frankly. But it certainly said, if it says prior to transport for testing, when when the judge clearly believes that it's still at the barracks.
But you weren't even interested in the gun.
Right, but...
This is the problem with ex parte hearings. This is one of the problems with ex
It
parte
seems to me
hearings.
you dug your own grave in this case.
Well, because we're not interested in the gun, that gives the Commonwealth the right to disobey a court order.
But I don't know that it gives the court the right to impose a $25,000 fine.
Well, again, as to the amount of the fine, frankly, I'm not particularly concerned. But I think it's absolutely essential that this court find that the Commonwealth needs to be sanctioned for their conduct here.
For what?
For what?
For testing the gun at 9:43 when there's explicit court order not to transport it for testing, which has to be read as not to test it.
But it was already transported.
I understand, but it's clear that the court thought that that has to be read as not only can't you test it, you can't even transport it for the testing.
Well, the Commonwealth doesn't know because you went ex parte. They don't know what it is you're after, and the order did say don't transport it for testing. It
Right.
didn't say don't test, it said don't transport. So maybe for some reason you don't want to transport it. That's one of you took that risk.
I understand that, but I suggest that's a very far-fetched interpretation of Judge Singleton's
Well, not
order.
only was the gun already at the lab, it had already been tested. It had been fired on September 5th right? So it was
Correct.
already in the process of being tested.
Correct, we didn't
So it
know
had already
that.
been transported. The testing had already started. There was no order here saying stop all testing, right? There was no order that said stop all testing on the gun.
Since nobody, including Judge Singleton, knew that the testing had started, it would have been hard to get an order that said stop
Nobody
the
knew
testing.
because you had gone ex parte.
I'm not convinced that that's the reason. The Commonwealth has talked about the miscommunication between the lab and the DA's office many times. They talk about this whole thing being a result of miscommunication. And by the way, I don't quite understand. It seems to me that who in the Commonwealth's on the Commonwealth's team dropped the ball is an interesting question, but not particularly relevant to me. That it's one, for discovery purposes, they're all one team, and whether it was the lab or the DA's office or any combination thereof is irrelevant. The question is, did the prosecution team commit misconduct? Not, who to blame. The Commonwealth can decide that. And their argument that, the marijuana needed to be swabbed for DNA was not advanced in good faith. They didn't believe that for a second. Marijuana bags are never swabbed for DNA, and if they had even done a rudimentary investigation, they would have discovered that this had been handled by so many officers that a DNA swab was impossible.
Okay, but what the sanction was for a violation of the order, not for making a frivolous argument. So what difference does it make as to what the Commonwealth's argument was as to why it wanted the order vacated?
Suggest filing a false affidavit. By the way, and
But the judge in his footnote expressly said that he did not in any way rely on the affidavit and it had no consequence.
I suggest that is still not even if that's true. The idea that it's okay to file a false affidavit as long as nobody relies on it strikes me as a...
But you're asking us then to affirm an order on a ground that the judge himself did not rely upon?
Okay. Well, I suggest that they, first of all, I suggest that he relied on the gun evidence, and I think he had every right to, because whatever the reasons behind the defendant's request, the gun evidence was clearly included in the order. They clearly swabbed it at 9:43. After faxing an affidavit at 9:41 to the DA's office, it gets filed with the single justice sometime that morning. It is false when filed. When they find out that it's false, they do not correct it. They simply withdraw their opposition to that portion of the order. It seems to me that my reading of the rule says they have to do more than that. They have to come forward and say, that affidavit we filed, well, at the time we filed it, we believed it, but we found out later it's not true. They never said that to anybody. And I suggest that it's clear that's what the ethics rules require, not just, well, I'll just withdraw that, and I'm not going to tell you why, because I don't want to, make us look bad. And the idea that they can... The unsigned part of the order, I don't quite understand that. When I get orders, protective orders or whatever, I have never been served with a signed copy. It would never occur to me that I could disobey it simply because I didn't have a signed copy. Same thing if it was an ex parte order. It wouldn't occur to me. I would certainly go up on a 211.3 and do all that. But while it's in effect, the Commonwealth, as well as everybody else, has to obey the court order.
Okay, so if you would finish this sentence for me in terms of what you think this court should say, that a judge is authorized to issue a fine against the Commonwealth in those circumstances where, why don't you finish that sentence?
They disobey a court order.
Whether it's willful or unintentional.
I suggest that, yes, that certainly that should be taken into account, but it is not an excuse. The fact that they have, and I'm not sure that the judge had to find. The Commonwealth maintains it was not intentional. I'm not sure the judge had to find that it was unintentional.
And your view is that would apply not only to the Commonwealth, but say to a defendant under the same circumstances?
Absolutely.
That a judge may fine a defendant where he finds that there was a non-willful disobedience of the court order?
Correct.
Okay, unless there are any other questions, Mr. Beck, thank you.
Thank you.